51% of parents say their teen uses an AI chatbot. 64% of teens say they do. There is a real parent-teen awareness gap here, and it's probably not because teenagers suddenly became transparent. With such a growing use of these tools among teens, there is question of whether they are safe or not. Because at the same time, families are in court alleging that AI companion chatbots became part of catastrophic outcomes for their children. Regulators are investigating, states are passing chatbot-specific laws, and Congress is throwing bill after bill at the wall because apparently move fast and figure out the child safety framework later has consequences. What you're watching is an accountability gap, getting exposed in real time. And courts, state legislature, Congress, and the companies themselves are all trying to feel it at once, with fundamentally different theories of what the problem even is and whether the fix looks like banning these tools, redesigning them, or something nobody thought of yet. Hi, I'm Kate, attorney and certified privacy professional. Welcome back to Sunshine&Side-AIs. Quick disclaimer. This video is for educational purposes only, not legal advice. I'm sharing research, not giving counsel. A content note. This video discusses cases involving teen suicide. If you or someone you know is in crisis, the 988 Suicide and Crisis Lifeline is available 24/7. That number will be on screen throughout those sections. Here's what's actually happening. Multiple families have filed lawsuits alleging that AI companion chatbots played a role in catastrophic outcomes for their children. Across the complaints, families allege a recurrent pattern. A teenager starts using a chatbot for companionship or emotional support. The chatbot fosters dependency through around-the-clock engagement and emotionally intimate responses. And at some point, the relationship crosses into territory no responsible human would allow. Sexualized content served to minors, encouragement of self-harm, active discouragement from telling parents. These are allegations. The cases are in various stages of litigation, but the volume and the consistency of the pattern matter because they're now driving the legal and regulatory response I'm going to walk you through. And the case level allegations are not the only signal. When Common Sense Media and Stanford's Brainstorm Lab ran a systematic risk assessment of the leading chatbots, ChatGPT, Claude, Gemini, and Meta AI, they sent thousands of teen account prompts simulating distress across depression, anxiety, eating disorders, and more. Their conclusion: these tools are, in their words, fundamentally unsafe for teen mental health support. The chatbots consistently fail to recognize and appropriately respond to mental health crises, and instead prioritize continued engagement over referral to actual care. One important caveat on methodology. That study was red team testing, simulated distress prompts designed to probe what the chatbots can do under adversarial conditions. That's valuable and alarming. It's not the same as measuring what they typically do in everyday teen use. But we do have data on what teens are actually doing with companion chatbots specifically. Common Sense Media surveyed over 1,000 teens in the spring of 2025 and found that a third of teens who use AI companions are using them for social interaction and relationships, emotional support, friendship, role play, even romantic interactions. A third of those users have chosen to discuss something important or serious with a chatbot instead of a real person. And a quarter have shared personal information, their real name, their location, their secrets. One more number worth paying attention to. Younger teens, 13 and 14-year-olds, are significantly more likely to trust advice from an AI companion than older teens. Some respondents may have blurred the line between general AI tools and companion chatbots, which could inflate these numbers. But the pattern is consistent with what the lawsuits describe. It's just not limited to the catastrophic cases. So the harm signal is real. And if this were a simple story, we'd stop here, pass a law, and go home. It's not a simple story. Last November, JAMA Network Open published the first nationally representative study of how teens actually use generative AI for mental health. The study, led by RAND, funded by NIH, found that about 13% of US youth ages 12 to 21 have used AI for mental health advice. And of those who have, around 93% say it helped. I need you to sit with that for a second. I would also want you to keep in mind that I feel helped is not the same as I'm helped. Perceived helpfulness is not clinical efficacy. The study's own authors flag that. But it means this: The very populations these regulations are trying to protect is also the population that believes the tool is working for them. That's not a minor complication, that is the central policy problem. There is still no robust youth specific long term causal evidence that answers the core policy question cleanly. We have case allegations, survey, red team testing, and preliminary trials. Both the APA and pending federal legislation are calling for the NIH funded long term research. It doesn't exist yet. So here's where that leaves us. The harm pattern is real and serious. The data underneath it is incomplete and contradictory. And that combination, real harm, messy evidence, is exactly why the regulatory response looks the way it does. And one more thing worth naming before we get into that response, this is not just a replay of the social media fight. The APA flagged this explicitly. Unlike social media, adolescents may not even realize when they're being influenced by AI. And AI doesn't just spread misinformation the way social media does. It generates false information in ways that feel authoritative, that make user believe it's true. The mechanism of influence is different, which means the regulatory playbook has to be different too. So if the harm is real and the evidence is complicated, why can't we just pass a law and fix it? There are three structural problems. First, legislatures and courts are using different definitions of what a chatbot even is, resulting in potentially different requirements across jurisdictions for similar systems. Two defenses have shaped platform litigation for decades. First Amendment with the argument that platform output is protected speech, and Section 230 of the Communication Decency Act, which in plain English says that if a platform hosts someone else's content, the platform generally isn't liable for that content. You post something harmful on a social media site, the site is a distributor, not the author. Those two defenses have worked extremely well for social media. The problem is that an AI chatbot doesn't host someone else's content. It generates the content itself. There's no third party author. The output is generated by the system, not posted by a separate human user. So the question becomes, does Section 230 still apply when the platform isn't distributed, it's creating? And is that creation speech? In May 2025, a federal judge in Florida, Judge Conway, in the Garcia case, gave the most significant ruling we have so far. She wrote that she was not prepared to hold that Character.AI's output is speech, and that defendants had failed to explain why words thrown together by a large language model should get First Amendment protection. She also declined to block the product liability claims. And here's why Conway's reasoning matters for everything that comes after. She drew a line, and this is the doctrinal hinge, between the content a chatbot produces and the design decisions that determine how it behaves. The content might be speech, but the decision to keep a teenager engaged at 3 in the morning without notifying a parent, the decision not to flag a crisis and refer to a human, those are product design choices, and the order allowed product liability claims to proceed on that basis. That content versus design distinction is going to show up in almost everything you see for the rest of this video. The state bills, the federal proposals, the industry responses, they're all landing on one side or the other of that line, whether they realize it or not. But, and this matters, Conway's ruling was at the pleading stage. It is contested. The Foundation for Individual Rights and Expression has filed an amicus brief arguing that Conway's framework could chill protected speech and lead to government-driven content restrictions on AI platforms. Legal scholars on the free speech side argue this is doctrinally wrong. The question is not settled. It is being fought over in real time. Second problem, age verification. The most intuitive solution, just verify that users are old enough, creates a different set of problems. The Electronic Frontier Foundation has called the leading federal proposal, the GUARD Act, a surveillance mandate disguised as child safety. EFF's position is that age verification becomes identity collection and practice. It requires you to prove who you are before you can speak. And as one example of why privacy advocates worry about age verification data, this court said a third-party customer support provider used for age-related appeals was compromised, exposing about 70,000 government ID photos. Third problem, the landscape itself. 64% of teens use chatbots, and they are spread across multiple platforms: ChatGPT, Gemini, Meta AI, Copilot, Character.AI, and more. A rule that covers one platform doesn't cover the next, because similar companion like interactions exist across multiple services. Platform specific restrictions can leave obvious substitution problems. And underneath all three of these structural problems sits the fact that we started with. Nearly 3 in 10 parents aren't sure whether their teen uses chatbots, and parents underreport use compared with teens. That's the landscape. So let's look at who's actually trying to fill the gap and how. There are four tracks running simultaneously right now: courts, state legislatures, Congress, and the companies themselves, mostly under pressure from the other three. Let me walk through each one, because they're all operating on different theories of what the problem actually is. And if you caught the distinction we just drew, you'll start to see which ones are trying to regulate what chatbots say and which ones are trying to regulate how they are built. Track 1: the courts. The Conway ruling we just discussed didn't just question whether chatbot output is speech. It potentially opened the door to treating AI chatbots as products, subject to design defect and failure to warn liability. That's a fundamental shift. For decades, tech companies defended themselves by saying, "We're a platform, not a publisher." Conway said, "Maybe, but if your product's design causes the harm, not the content, but the design, then it is a product for the purposes of plaintiff's product liability claims." In January 2026, the Garcia case and four other family lawsuits settled. Terms are confidential. What that means for the public is significant. Because the case settled before summary judgment, we may not get a binding ruling that clarifies exactly where the line is between product liability and Section 230 First Amendment protections for AI chatbots. Conway's analysis was at the pleading stage. The question of where that doctrinal line ultimately falls remains open. Meanwhile, a separate enforcement track is just getting started. Kentucky's Attorney General filed the first state consumer protection action against Character.AI in January 2026. Texas is investigating under its Scope Act, and 44 state attorneys general sent a bipartisan letter to AI company CEOs in August 2025 that included this line: "We wish you all success in the race for AI dominance, but we're paying attention. If you knowingly harm kids, you will answer for it." That letter was triggered by a Reuters investigation revealing internal Meta documents that authorized Meta AI to engage children in conversation described as romantic or sensual. The Attorney General's message was simple: social media taught us what happens when regulators are slow. This time, they're not waiting. Track 2: the states. New York was first. GBL Article 47 took effect November 5, 2025, the first AI companion law in operative force in the US. It requires crisis intervention protocols for suicidal ideation, disclosure that the user is interacting with AI, and periodic reminders every 3 hours of use. California followed with SB 243 and AB 1043, both signed in October 2025. SB 243 targets companion chatbots specifically. AB 1043 takes a different approach, pushing age verification to the operating system level rather than individual apps. Washington signed HB 2225 in March 2026, effective January 2027, which notably includes a private right of action, meaning individuals can sue, not just the Attorney General. As of mid-April, the Future of Privacy Forum is tracking 98 chatbot-specific bills across 34 states. And if you're listening for it, you can hear the content versus design split running through the whole landscape. Some of the bills regulate what the chatbot tells the user: disclosure requirements, crisis response mandates. Others go after how the product is built: manipulative feature bans, engagement loop restrictions. And some try to do both, which is why compliance is turning into a patchwork where the same chatbot may face entirely different rules depending on which state it's accessed from. Track 3: Congress. At the federal level, there are now at least 5 competing proposals, and they disagree on what the problem is. To give you the range, the GUARD Act wants a flat ban on all AI companions for anyone under 18. That's the most aggressive content side approach. The Chatbot Act, introduced as recently as April 28, goes the other direction. Family accounts with parental visibility into chat topics, regulating the product design rather than their access. In between, you have proposals focused on parental consent, disclosure and crisis protocols, and data collection restrictions. All five are on screen. They're all bipartisan, the coalitions cross cut. And they reflect genuinely different theories of what the harm is and how to fix it. Is the problem that kids can access these tools at all? That the tools aren't transparent about what they are? That they're designed to manipulate? That they collect too much data? Every bill answers a different version of that question, which is why none of them has a clear path to passage. One more federal note worth tracking. The FTC launched a formal Section 6B inquiry in September of 2025, sending compulsory orders to 7 companies: Alphabet, Character.AI, Meta, OpenAI, Snap, Instagram, and XAI, demanding information on safety assessments, age gating practices, and how they use minors' chat data. I didn't find a published FTC findings report as of filming. When that report drops, it could reshape the entire legislative conversation. Track 4: the companies. Industry has moved, but the timeline is hard to read as coincidence. The moves come after lawsuits, after Senate hearings, after investigative reporting, not before. Character AI banned open ended chat for users under 18 in November of 2025. The timing followed the Garcia case, Senate testimony, and additional lawsuits, though the company has not said any one event caused the change. Minors still have access to image generation, video, and other features. OpenAI added parental controls, retuned its models for tighter mental health restrictions, and launched a network of 170 mental health professionals to advise on model behavior. The timeline of those changes overlaps with the RAIN litigation and broader regulatory scrutiny, though OpenAI has framed the changes as part of its ongoing safety work. The most notable recent industry shift is Meta. In January 2026, Meta suspended teens' access to its AI characters globally, days before a New Mexico child safety lawsuit went to trial. That lawsuit was about Meta's broader platform practices with children, not AI chatbots specifically. But Meta still lost the case, reportedly the first court verdict holding Meta liable for endangering child safety. In February, Meta upgraded teen accounts to alert parents when teens search for self harm terms. And in April 2026, Meta rolled out a parental supervision feature that lets parents see the topics their teen has discussed with Meta AI in the past week. So, in a compressed timeline, Meta paused teen AI character access, lost a major child safety verdict in New Mexico, and then rolled out parent facing AI topic visibility. The AI chatbot specific changes aren't directly at issue in the New Mexico case, but the parallel is hard to miss. The company's approach to child safety across its products shifted substantially in a compressed time frame. Whatever you think of the sincerity, the business reality has changed. So, if you're a parent watching this and the honest answer is the rules are still being written, what can you actually do with that information right now? I know the question underneath that question. You want to know whether you should let your kid use these tools. This video can't answer that for you, not because I don't have a view, but because that's a family decision that depends on your kid, your household, and your risk calculus that no one on YouTube can make for you. What I can do is tell you what's actually available so the decision is informed. A few things that are just observable facts. Several major platforms now have parental controls or parental supervision features for AI interactions. The specifics and the quality vary and they change frequently. So I'd encourage you to check what's currently available on whatever platform your child uses. Many platforms publish age policies in their terms or help centers. Whether those policies are enforced consistently is a separate question, but you can at least see what the company says it does. And if you want to know more about what those platforms are actually doing with users' data, I have a video where I ranked the major AI chatbots on privacy. Link is in the description below. And there are genuinely useful expert resources that are free and public. The American Psychological Association has published 2 health advisories, one specifically on AI chatbots and mental health, that are written for a general audience. Common Sense Media has both a risk assessment of deleting chatbots and a research report on how teens actually use AI companions. These aren't marketing materials. They are from organizations with the relevant expertise and they are available to anyone. Now, what's worth watching from here? The FTC's Section 6B inquiry. 7 companies were ordered to hand over information on safety testing, age gating, and how they handle minors' data. When that report drops, it could reshape the federal legislative debate. Whether the Conway ruling gets an appeal. Fire has filed an amicus brief supporting one. If a higher court takes up the speech versus product question, it could either entrench Conway's framework or dismantle it. The federal preemption question, meaning whether a federal law could eventually wipe out parts of the state by state patchwork. The December 2025 executive order directed agencies to identify onerous state AI laws, but explicitly carved out child safety protections. And bipartisan attorney general coalitions have pushed back hard against preempting state regulation. How that plays out remains open. But for now, the carve out is part of why 98 state chatbot bills are still alive. And whether any of the federal proposals actually converges into something that can pass both chambers. AI chatbots are already part of teen life. Some kids use them for school, some use them for fun, some use them for emotional support. And some families are now in court alleging that these same tools became part of devastating harm. The accountability gap isn't that nobody's doing anything, it's that everybody's doing something different. Courts, states, Congress, the companies, and there is no clear consensus on whether the problem is what the chatbot says or how it's built. Policy whiplash is apparently the new cardio. Meanwhile, the kids are still in the middle. Sources are linked in the description below, along with the date this landscape was last checked, because this area is moving fast. If you want more AI privacy, ethics, and policy analysis without the hype cycle doing interpretive dance on your brain, subscribe to Sunshine&Side-AIs. The rules are being written, the only question is whether they'll be finished before kids are grown.